Hello, good afternoon, and welcome to episode number 52 of At Your Service with Haber and Martinez. I'm Haber.
Yep.
That's Martinez. Am I going? Which way am I going here? Left or to the right? Episode number 452, and we're going to dovetail on what we did last week, which is dissecting more real-world, current, local, and criminal cases. Just like last week, we pulled two cases out of the Broward County Clerk of Court's website. Today we pulled three, and hopefully we'll be able to get to all three of them. And the idea here is noting that we know nothing at all about these cases other than the police, law enforcement statement of probable cause. Again, anybody who gets arrested and booked into any jail in the state of Florida must have a probable cause affidavit that can be reviewed by the judge after their booking. And that statement of probable cause is 100% created by law enforcement for the state. And if the four corners of that document contain a statement of probable cause and the person was lawfully arrested, and you get to the next phase of the state being able to try and prove guilt beyond and to the exclusion of reasonable doubt with competent, substantial, and admissible evidence in a courtroom. So we're just at this initial phase. Neither Ed nor I know any of these individuals. We've never been consulted by them. We've never spoken with them about their version of events. So it's a limited discussion that we can have where we are wearing our legitimate hats. Ed his hat, me, hashtag HaberPA. But either way, we have our criminal defense attorney hats on. So we look at these documents and try and figure out, are there any kinks in the armor? Are there any obvious defects? Are there any latent defects? Is there any crack or crevice that we can put our proverbial chisel into and start chipping away at?
Mike, I'm sorry to interrupt you. I don't know if it's you, but right now you sound like Wally from the Disney movie, The Robot. Try it again. If not, I'll pick up.
I don't know what that means. Can you not hear me?
Log in and log back out. I'll take the mantle till you come back in. It's like a relay race.
Maybe it's my headset.
Could be. So what Mike is getting at is we're going to look at this, and what you're going to see is in real time, real world, how it is that lawyers are, humbly speaking, good lawyers will do it. We have it. A lot of the times, the vast majority of the times, I'm sure Michael agrees with me, we love to read the A form. Sometimes we're stuck just with what the client tells us. But, the A form helps us. But we also understand that the A form is not the end all and be all of what actually happened. The A form, like I tell my clients, is the officers are putting in an A form only what they believe is necessary to arrest you. They don't necessarily put in there everything, especially if they think it's something that they thought didn't really matter to them in making their arrest decision. But that doesn't matter. It doesn't matter to us. Yeah, you're still sounding like a robot, brother.
Still sound like Wally. All right, let me just take these off in their entirety and see how the speaker works on my iPad. How's that? Can you hear me now on this thing?
A robot. I think you might just log in and log back out. Is there anybody in the production?
Tell me if you can hear me better now.
Still sounding a little bit.
All right, one last ditch effort, and then I'm going to log out and log on. But I'm going to try another different pair of headsets and see how that works.
All right. So again, so we look at these and we have to ask a lot of questions. We as we said in the last show, a good defense lawyer, any lawyer, to be honest with you, that's a litigator or a trial lawyer, because litigators are not necessarily. A lawyer is always 20 steps ahead. To us, it's a chess game. We have to anticipate every move that can possibly be made, every move that we can possibly make in response to every move that the other side can make. All that goes through our head in a nanosecond. We're really, these three cases, we're pretty much condensing them and making it quick, but we will be here for hours trying to tell you everything we anticipate and how we really start looking at cases from the minute the client walks in, from the very first moment they speak to us. Right, Mike?
How's the sound check now?
Log in, log out, and log back in. If you guys can log in, is there anybody at the studio can help us there?
I'm back in.
All right. So Mike and I did this last week. We're doing it again with a couple of cases so you can understand what's going through our head. And in the process, we'll help you understand what probable cause is, why they say certain things, why officers write certain things on the arrest affidavits that are necessary for them to get probable cause, what it is that we're looking at, because in our experience from all the years we've been doing this, a lot of times we can look at these arrest affidavits and we can see what's missing, what doesn't really make sense, or things that perhaps they're in the arrest affidavit, but we can see that there's a little more to it, and that's where we're going to do motions or we're going to take depositions. Although Mike doesn't like taking them, which I agree with Mike. Good lawyer doesn't have to take depositions. I'm not going to reveal my secrets, but there are times where I take depositions, and my depositions are very strategic. They're almost surgical, to be honest. And there's a reason for that, because honestly, I don't need to take their depositions, as Michael will probably confirm, because we know 90% of the time they're going to say exactly what they wrote on the A form, because before they come to the deposition, they review what they wrote and make sure they say exactly what they wrote on the arrest affidavit or the offense incident report. So good lawyer's been around, doesn't really need depots. I just sometimes take them, but it's for surgical reasons.
All right, doctor. Can you hear me better now?
Now we got you. I gave him the
Okay.
Get right to the case. We're 6 minutes in, so let's go.
All right. So I just want to say again, I just want to reiterate one more thing, and that is it's very important when we assess these cases. What we're doing is, again, we're looking at the police version of events, but at some point, were we to actually be consulted by any of these clients, we'd need to get into their version of events as well. Obviously, it's very important for us to know what it is that they have to say, because they may provide us context that law enforcement doesn't have. A lot of times people refuse to talk to law enforcement, right? If you hashtag up X2 and you don't tell them your version of events, they don't know your version of events.
And if you're smart, you'll do it because of what I just said earlier. Remember, the
But-
officer said, this is not a knock. This is not unethical. This is not something that has to be revamped in the justice system. This is what they do. They go in looking for facts that'll give them probable cause to arrest. If they don't find facts that give them probable cause to arrest, they do not arrest. They are not there looking for facts to exonerate you. That's not really what they do. And I would need a 4-hour show to explain exactly what I mean by that. I know it doesn't sound good, but trust me, it's nothing unethical on their part. They're looking. It's like telling me that a surgeon is going in because you have a pain in your liver and you want him to find out if you have any other issues in your spine or your head or somewhere. That's not what he's there for. He's there to find out what's wrong with your liver. That's all.
All right, Mr. Liver.
Yeah.
Let's get on to our first arrest. So on October, again, I'm going to read this arrest report and then we'll go through them. First one happened on October 1st, 2022. At approximately 5:05 a.m., defendant was driving his 2008 Kia Sorento southbound in the 1100 block of South State Road 7 when he struck the rear end of a southbound Toyota Yaris. This collision caused the Yaris to strike the rear of a 2017 Hyundai Sonata. So you have a 3-car accident, right? Our guy, or this guy, the defendant, hits another car from behind, which forces that car to hit a third car. So it's a sandwich. It's a daisy chain. The collision caused the Yara, which is the middle vehicle, to catch fire, thereby further injuring the victim, who sustained burns over 20% of her body, including to her face, right shoulder, lower back, and both of her arms. North Lauderdale Fire Rescue responded and transported victim to Broward Health North. She had extensive, although non-life-threatening injuries, and that required her to be expedited transport to the burn unit at Ryder Trauma Center in Miami for specialized treatment. The driver of the other vehicle was shaken up but did not require transportation to a hospital. Deputies Ray and Mendez responded to the scene with multiple other deputies. Deputy Ray conducted a traffic crash investigation. Deputy Mendez assisted with Spanish translation. Both deputies were in direct contact with the defendant, observed him to have red, glassy eyes and an odor of alcoholic beverages emanating from his breath as he spoke. The defendant stated he was going home from a nightclub. I was contacted at 6 o'clock, but was unable to respond to the scene until 6:34 to conduct a DUI investigation. I arrived at 6:49 a.m. I was informed of the aforementioned by deputies Ray and Mendez. At 7:22, I contacted the defendant, who was seated in the back of a patrol vehicle. I learned during the course of the crash investigation that the defendant had difficulty listening to safety instructions. He kept walking around the damaged and fire-engulfed vehicles. He was escorted to a patrol vehicle where he sat in the back seat. He was not handcuffed. He was never told he was under arrest. He was not free to walk about the scene. However, this was for his own safety. He exited the vehicle in the Home Depot parking lot where I contacted him. I introduced myself and made initial observations of glassy and bloodshot eyes. During conversation with Spanish translation, I further detected an odor of alcoholic beverage emanating from his breath. I informed him that the crash investigation was complete, and based on Deputy Ray and Mendez's assessments and of my own observations, I was now going to initiate a DUI investigation. I requested he perform roadside sobriety exercises, to which no objection was made. The defendant told me that he had injured his left wrist in the crash. He stated he was not diabetic, he was not taking medication, he did not wear contacts or glasses. He did not have any other injuries, illnesses, or balance issues, and he felt healthy. The following exercises were individually explained and demonstrated prior to the start of each exercise. Exercises were conducted and performed in the parking lot next to the crash scene. Horizontal gaze nystagmus. Defendant had difficulty keeping his head still as he followed the stimulus. He had to be reminded not to move his head. He had equal tracking, equal pupil size, and no resting nystagmus in either eye.
You're a robot again, my friend.
He displayed a lack of smooth pursuit in both eyes. It is same and sustained nystagmus at maximum deviation and an onset of nystagmus prior to 45 degrees. Does nystagmus observed during the vertical walk and turn?
Mike, it's hard to hear you. It's really hard. We can't understand you.
Okay, so again like this.
And you're gonna have to log off again.
All right, walk and turn. Same?
Yeah, same. I don't know what's going on with your audio, but it's really bad. We can barely understand you at all. So I don't know if you just want to log on quickly and log back on. Log off and log back on quickly. It didn't take you long. Just do it again and come back on.
All right, give me 1 second.
Okay. For whatever reason, I only have the 1A form. I lost the other 2A forms. I have to log on again to get those, but I do have, let's see if I can pull this one up again.
I'm going to try this without headphones and just using the microphone. Can you hear me better now?
Yeah, you're good again.
Let's see if it stays. Walk and turn. Defendant failed to keep his balance while listening to the instructions. He walked forward 11 steps, placed his hands behind his back as he walked. He turned around and took 10 steps backwards, keeping his hands behind his back as he walked. He did not count his steps out loud as instructed. One leg stand. Defendant extended his arms outward and high, attempting to balance. His foot swayed side to side while balancing. He counted out loud, repeating numbers 1 through 13, but he did not count as directed. 1, 1001, 1002, 1003, etc. I placed the defendant under arrest at 7:39 hours. I requested a breath test, to which he replied he would not provide. He was read in Florida's implied consent law, to which he still stated he would not provide breath. Due to the nature and the extent of the injuries to the victim, I requested a blood sample. He refused to voluntarily provide blood. Deputy Mendez read the defendant Miranda. The defendant stated he understood, but he refused to answer questions. Photographs of the scene were taken and uploaded to evidence.com. Deputies Ray and Mendez completed supplementals. The defendant was transported to Florida Medical Center for medical clearance. I notified Sergeant of this information. A search warrant was authorized. I completed paperwork and received approval from an ASA. Judge approved the search warrant, allowing 2 blood samples to be taken from the defendant. An RN withdrew blood samples from the defendant with the approved blood draw kit at 10:36 and again at 11:41. The blood draw kits were transported to the Broward County Medical Examiner for further analysis. The defendant was transported to the jail for further detention. There is body worn and vehicle dash cam. The charges in this case are DUI, DUI serious bodily injury, 2 counts of DUI property damage, and careless driving.
Right. You want to start? Where do you want to start?
So I have a couple of things I want to hit on this. First, I want to say he refused breath. He took roadside sobrieties. he would have been much better off had he refused both. Okay. A double refusal would have given them very little evidence other than the fact that there was an accident and that they observed bloodshot eyes, watery eyes, and smelled alcohol, but they had nothing more.
But for the alcohol, the bloodshot, watery eyes could be explained from the accident. Could be
explained from a number of things. The problem in this case is that somebody was injured and had serious bodily injury, which is why they got a warrant to take blood. So the double refusal is all good and fine until they get a warrant to take your blood. And if the blood comes back above, then you're double screwed, because blood is a lot more difficult to deal with than breath. But still, I would say, as a general rule, we talked about this last week, so I don't want to get too deep into the weeds, but we have an implied consent law in the state of Florida where law enforcement must tell you that you have a right to refuse breath. But they do not have any implied consent law or any obligation to tell you that you have an equal right to refuse road signs. So usually what they do is they ask you to take road signs in a way that suggests you don't have an alternative. Whereas when they ask you for breath, they have an absolute unequivocal legal obligation to tell you that you do not need to do it. So those are a couple things. And then as far as the warrant goes, I would say this is a case of pretty good police work, because securing a warrant with the assistance of an assistant state attorney and obviously the approval of a judge on scene is going to be a much more difficult hurdle to overturn later when you've got other judges reviewing the calculus made by one of their colleagues in the moment. So given all that, the serious bodily injuries that were involved here, it looks like it's a relatively clean case. Right. There's not a whole lot for us to latch on to.
Unless, of course, that blood draw comes back with 0. But the more realistic scenario that would be to his benefit would be, Mike, correct me if you agree with me. Let's say he had been drinking a little bit, and now it comes back with a 0.04, right? Not a 0.08, but a 0.04. 0.06 and above, the state can still say, well, you can't presume that he's impaired, but we can argue it. Now he's a 0.4. One of the things that the state would like to do, since it took so long to get his blood, they're going to try and bring in an expert, perhaps, that'll extrapolate where he was during the accident to show that the time that passed.
In order to do that, though, they need a timeline. They need to know when he was drinking. They need to know how much he drank. They need a lot of information that they don't have in order to do that.
And that's what I was trying to get at. What I was trying to get at is they do still have something that they will argue, and probably can and probably will argue. But the point is, it's still going to be a much difficult journey for them. Now they've got hurdles that they're going to have to overcome, because, as Mike points out, they're going to need to be able to put a timeline. And without any kind of confession, or without him saying anything about, I was having dinner, where he was at.
There's no indication that he made any statements like that.
Right. It's going to be hard for them to be able to put a timeline together to be able to make that argument. So
the only other thing that I want to mention about this case is it's another example of good police authoring of an arrest report. This officer is a DUI certified officer. The reason he was called on scene was specifically to conduct this investigation, this evaluation, and to write this report. I mean, that is why he was there. And he obviously took great pains in doing it. For instance, and the one thing I want to talk about, I'll get to in a minute. But for instance, when he talks about how he had been placed in the car for his own safety, right? He's very clear to say that because he doesn't want to give the impression that this guy was already in custody and under arrest at that point in time, because if he is, he's got to be read Miranda. So in other words, they were detaining him, but he was not in custody. And he goes on to say, assuming that some defense lawyer, no doubt making the assumption that some defense lawyer is going to argue that this guy was actually in custody because he was in a police car and he couldn't open up the door and leave if he wanted to, right? But he's saying the reason that he was there was for his own safety, because while these cars were on fire, he was walking around and he potentially put himself in danger. So these officers had to put him there to protect him from himself. So that was some pretty good creative writing. And then again, I also, highlight the fact that this guy reached out to an assistant state attorney. He put the state attorney's name in there. He reached out to a judge. He put the judge's name in there. He really dotted I's and crossed T's. The only the thing I want to mention about this case is everyone should know that there's a thing in the law called privilege, and you know it whether you know it or not. When you consult with an attorney, if you have a private consultation with an attorney, whether it's over the phone, in person, on FaceTime, it makes no difference. That discussion is, unless you do something to open it to the rest of the world, it is privileged. Why is it privileged? Because there's a thing in Florida law called the attorney-client privilege. There's other privileges that you know of, whether you know them or not. Doctor-patient, psychotherapist-patient, husband-wife, accountant, taxpayer. We have several of these privileges. Well, there is a privilege called the accident report privilege. And one of the reasons in DUI accident cases that they call in DUI officers is to make sure that there is no confusion in the mind of the accused as to what is going on in that moment. Because if they are conducting an accident investigation, two things happen. One, you are not under arrest. So you're not in custody and you're not being investigated for a criminal act directly. You are being investigated for your knowledge and the information that you can provide relative to the accident investigation. So anything that you say during the course of that accident investigation is privileged. We have a privilege in the state of Florida called the accident report privilege. So if Officer Martinez asks Citizen Haber, tell me about this accident, no matter what I tell him, it is inadmissible in any case, even my own subsequent criminal arrest. But the minute that they shift gears, we call it the changing of hats, to a criminal investigation, they have to tell you. If you're the target, you need to know that you are no longer subject to the accident investigation. You are now involved in a criminal investigation. And at this point, anything you say can and will be used against you. So y'all should know that as just a collateral, kind of an aside to take out away from this. Anything else in this case, Ed?
Yeah, I just want to briefly also mention as an example of what I said earlier, and it's not a comment on anything doing inappropriate on the law enforcement. They have their job. For example, he said that this guy was walking around the car that was set on fire. Well, one of the things that I, as a chess player, I'm 20 steps ahead. I want the
body worn and dash cam.
No, not the body worn.
Well, that's something you're going to get because according to the A form in this case, there is both body worn and dash cam. So
right, but I'm
doing that.
What I want is the fire rescue was called to the scene for the woman that was burned, and she was transported to the hospital. So hopefully that fire rescue report will give me a timeline because
you're not at that fire rescue report because there's another privilege. That's HIPAA.
Yeah, but you can get the report of when they got to the scene and who was there.
That fire rescue report is privileged.
Yeah, no. All right, Mike, you can get when they got to the scene, and you can definitely depose if there were any statements made. The reason what I can't get is what her injuries were, but you can get the timeline. And the timeline in this case may be relevant because if she was still in the car while he was going around the car that was on fire,
maybe he was trying to get her out,
mitigate her. And that's something I would want to ask the client. And that's something I would want proof of to show, listen, you wrote that you took him out of the way for his safety. And that is true. But the part you left off was that perhaps, let's say I'm right. You left off that he was doing it, trying to save the person coming out of the vehicle. So these are things that that we're thinking about, and we're not going to get to know what her injuries were and things of that nature, but you do get who called fire rescue, when they arrived at the scene, and when they left the scene. And those things may be relevant, and that could give us some insight into what happened.
All right, let's get on to the next one. The next case. This is the following day, October 2nd, 2022. While operating an unmarked police vehicle, which is equipped with lights and sirens, I was exiting the Driftwood apartment complex. I was exiting on the eastern side, which is a one-way only. The defendant was operating a white Hyundai Sonata. Defendant was entering into the apartment complex from the wrong side when there are clearly large signs that state, quote, "Do not enter." The defendant was driving right toward me. I activated my lights and my siren to notify the defendant that he was entering the complex in the wrong way. The defendant drove around me and stopped next to me with his window up. I had my window down, and I yelled at the defendant that he could not enter that way. The defendant then sideswiped my police vehicle, which caused minor damage to the rear bumper of my vehicle. The defendant failed to stop and provide information for this accident and instead drove away into a parking spot. The defendant exited his vehicle and became aggressive. I told the defendant that he just struck my vehicle and he needed to sit down and stay on scene. The defendant said that he did not hit my vehicle and he began to walk away. I attempted to grab the defendant. However, he kept pulling away from me. At one point, while attempting to grab the defendant's wrists, he swatted at my hands. I was then met with a large hostile crowd who were friends or family of the defendant. I utilized my department-issued ECW, that's a taser, twice on the defendant with negative results. The defendant pulled the ECW prong out of his clothes. I then deployed a short burst of OC spray with negative results also. The defendant became more aggressive and told me to, quote, back the fuck up and, quote, don't touch me. I then attempted to grab the defendant again. However, he pulled away from me and took an aggressive fighting stance towards me. Defendant pulled his pants up, balled his fists up, and put his fists in a boxing stance, which was an indication that he was going to physically brawl with me. Defendant was making lunging movements towards me. Defendant said to me, quote, what you gonna do? Defendant called me a, quote, pussy. Let it be noted that I was the only officer on scene. I was wearing an outer carrier which said police in large bold letters. I was in fear the defendant was going to attempt physical harm on me, a law enforcement officer. I was able to tackle the defendant to the ground, at which point defendant continued to resist arrest by tensing and bracing his arms. Defendant was placed into handcuffs. He was escorted to a marked police vehicle. He attempted to lunge at me and continued to tense and brace his body. Defendant was highly uncooperative during the duration of this incident. A FCIC-NCIC check revealed the defendant's license had been suspended. Defendant is charged with resisting with violence for swatting my hands, resisting an officer without violence for pulling away and ignoring my verbal commands, assault on a law enforcement officer for taking an aggressive boxing stance towards me with balled fists, hit and run, DWLS, and driving the wrong way in a lane of traffic.
This one's all yours, brother. You start on this one.
Okay, so here's the first thing that I want to say. On the roadside, the cop is king. He could be wrong as rain, but on the roadside, he or she is still king or queen. Just like in a courtroom, the judge is king or queen. Judge could get it wrong, and you have a remedy. It's called an appeal. You go to a judge that's higher up on the ladder to slap that judge back down to earth and tell that judge you were out of you were beyond the pale in this case. When you have a police citizen encounter, things are only going to get worse for you. You're going to pick up what we call gratuitous charges for your behavior subsequently. I don't know whether or not this guy hit that police car. I don't know if this cop was completely out of his mind. I don't know if he's lying about wearing a vest that says police. I have no idea if any of that is true or not, but here's what I do know. If that guy had simply not got confrontational with him, this thing would not have escalated to this. It wouldn't have even probably been a leaving the scene. Although, if in fact the guy did clip a police vehicle, even an undercover police vehicle, that's a lot of paperwork for the officer. It is a hassle. He's got to answer for it. And it opens up Pandora's box for him, right? But that doesn't mean that this guy is going to wind up with felony and bevy of felony and misdemeanor charges that otherwise didn't need to be there.
And I agree with you 100%. And while it's possible, right, there's all kinds of possibilities that we might be thinking out there. For example, maybe this officer backed up and damaged his own bumper and knew he was going to have a problem. So he made this whole thing up out of whole cloth. And this guy is absolutely correct. He never hit that vehicle. And this cop is completely full of crap. And he's making it all up. Maybe.
Could be.
If you stay calm, you'd be able to hire us.
How about
a private investigator to show there was no transfer of paint from his car to yours?
How about this? I'm the defendant, and the officer says to me, sit down, you just hit my car. Excuse me, officer. I'm calling 911. You're out of your fucking mind. Pardon my language. You're out of your mind. I want nothing to do with you. I'm not talking to you. I want real cops in uniforms with squad cars here right now. You dial 911 and you leave that call open and hope that this guy is ranting and raving in the background so that he sounds like a lunatic on that recorded call.
Or how about this option? apparently friends and family were there. Turn to one of your friend and family members and calmly say, do me a favor, call 911 and request that there's an officer on scene immediately, and don't hang up until they get here. I mean, there's a lot of ways that this could have been handled. No matter what the facts are, as egregious as they may have been, the way he handled it escalated it to a point where now he's got some serious charges.
I want to also, another thing that's curious to me is I don't know whether or not this officer had any rights at that point to say anything to this guy about coming in the wrong way. It's private property. So I don't know whether or not there's going to be an actionable cause there. In other words, the officer may have overextended, but again, private property or not, if the guy clipped the car and did not stop, and under the law in the state of Florida, leaving the scene of an accident, the most minor one that you can have is just property damage, minor property damage with no injuries. That's okay. It's not even a crime to do that if it's under, I think, $50. But if you just simply report, like, let's say you clip somebody's side view mirror or you scratch somebody's bumper and they're not there, just leave a note on their window and take a photograph of it to prove that you did it. Because that way you've now satisfied the requirement that you either remain on scene or provide your contact information so that the individual can reach out for repair of their damages. You've met your burden at that point. But again, it all comes back to judgment with this individual. So I'm not saying the officer's telling the truth here. And there, by the way, there's no indication there's body worn. So I don't know if there's going to be any surveillance, but that's certainly something Ed and I would want to know. We'd want our investigator out there right away to see if there's any Ring doorbells or if the security, the complex has security systems or there's any street surveillance that may have caught it, because we want to know whether or not the representations here's what we want to look at here, right? This document is a sworn affidavit. Okay. So if we are able to get video that shows that this officer's representations are inaccurate,
right,
that's our golden hammer right there. That's what we use to destroy this case, because these are sworn. This is a sworn affidavit by that officer. That means everything that he put in here is under oath. It's material, and it could even subject him to a perjury charge if we can prove that he flat out lied.
Absolutely. And, I think this guy was maybe not, but I'll tell you what bothers me when I see cases like this, that clients that come to see me. I wonder sometimes if they've seen too many of these TikTok videos and YouTube videos where you see these guys title it, guy owns officer, guy owns cop, and yells at him. And I'm telling you guys, don't fall for that. Do not fall for that. It's just a recipe for you to get arrested and have some serious problems. The best, like Mike says, the best case, I know what I'm doing. I know the law. Michael knows the law. And I'm always respectful to these guys until they cross the line. But if they don't cross the line, you got to be respectful, because you're going to lose that battle. If anything like it happened, this guy got worse.
I would also just throw out there, with regards to a situation like this. Oh, he got tasered too, and pepper sprayed.
Yeah, but I don't think the taser hit him, because it seems like the taser got caught on his clothes, which a lot of officers will tell you the reason they don't like carrying the taser. I know some officers who don't even have one, because if you carry one, that means you were certified. And if you're certified to carry it, it means that you fall under their use of force matrix. And if you are certified to carry that taser, you have to first go through that matrix, which involves the taser, before you get to the firearm. And some of them will tell you, if you're wearing loose clothing, the prongs get stuck in the clothes and never make it into the body. So they don't want to have to pull a taser to do that and then have to end up using their firearm. So I think that's what happened here. I think it got stuck in his clothes and never hit his body.
So the only other thing I want to say about this, and I just to be clear, even if you could do this with a marked police vehicle too, but if you ever get pulled over by an unmarked officer, or if you ever get approached by a plainclothes officer, you have every right to turn and call 911. And if you believe that there's some possibility that you're going to be robbed, carjacked, that this is a bullshit, claim that somebody's personating an officer, you have no way to verify that they're in fact cops. You have every right to get on the phone with 911 and preserve that and ask for other officers to be dispatched to the scene.
And if you're polite about it, they're not going to get offended. If you turn to them and say, listen, no disrespect, but I just want to make sure you're a real cop, I'm going to call 911. That's all. That's all you got to say.
Or again, if you were, let's say you were being pulled over, let's say you got lit up by an unmarked officer, you don't have to pull your car over right away. You can dial 911. I mean, they may charge you with fleeing and eluding or this and that, but if you can prove that you called 911 because you didn't know that that was an actual police car, and Ed and I can tell you, we've both represented knuckleheads who are not cops that have their cars wired with lights and sirens, and for whatever perverse or, disturbed reasons that they may have to do it, this is a potential problem for the public. So you could easily be pulled over by somebody who is not a cop that's personating a cop. You have every right to conduct an examination and determine whether or not it is in fact law enforcement. But like Ed said, you could do it politely, you could do it quietly. You don't have to be confrontational. And really, one of the worst things that you could ever do is take a boxing stance with a cop. That's just a really dumb thing to do.
Yeah,
I don't think there's any other way to put that. It's just dumb. You could be wrongfully arrested. Doesn't mean you take swings at cops, because even if you beat the rap, you ain't going to beat the ride to the hospital.
And I got news for you. This is not a movie. This is not a boxing ring. They're not there to prove to you that they can beat you mano a mano. They're there to make sure that you go down, because if you take them out, there's the fear that you could take their firearm, you could take their gun, their car. So they're not. You bring up fists, I'm telling you, they're not going to fist fight you. They're going to pull a taser. They're going to pull a baton. They're going to pull pepper spray. They're going to do something to make sure that the odds are way in their favor. So don't even risk it. Not worth it.
Here comes our last and Ed's favorite.
My favorite. I love this guy. I'm not sure what he was thinking.
This is October 3rd. So we had the 1st, the 2nd, and the 3rd. On Monday, October 3rd, at approximately 9:32 a.m., Broward Sheriff's officers responded to the Walgreens located in Commercial Boulevard reference a disturbance. Upon deputies' arrival, the defendant informed them that he was a law enforcement officer. Deputies then detained the individuals who were all prone on the pavement. There were 5 of them. We'll get to that. Broward Sheriff officers were notified of the incident, responded to the scene. Upon my arrival, I was informed of the following. I contacted the defendant, who stated the following. He was traveling eastbound on West Commercial Boulevard in Tamarack. This is the victim. The names are blocked out. Pardon me. They spoke to the victim first. The victim was driving eastbound on West Commercial Boulevard in Tamarack. The defendant pulled up next to the vehicle, yelling that the victim had cut him off. The victim continued driving. He stopped at an intersection. The defendant exited his vehicle, demanding the victim to pull over and displaying a badge. Victim did not believe defendant was law enforcement, and he drove away. It should be noted defendant was in a personal vehicle. There was no indication of that vehicle that he was law enforcement. Victim noticed the defendant following him. He attempted to drive through the Walgreens parking lot. He was cut off by the defendant's vehicle on the east side of the parking lot. The victim reversed his vehicle while the defendant was driving towards him. Victim reversed into a curb. Defendant crashed his vehicle into victim's front bumper, which blocked victim's vehicle in, preventing victim's escape. Defendant then displayed a black firearm, pointing it at the victim. Defendant created a well-found fear in the victim while pointing his firearm at him. I obtained sworn testimony from the other victims. The sworn testimony all corroborated that of the victim and the defendant. They added that the defendant had blocked the vehicle after they reversed to the curb, and that he had also demanded everybody to exit the vehicle and get on the ground. One victim added that she dialed 911 while the incident was taking place, and she remained on the phone with dispatch until deputies arrived. 2 other victims affirmed that the assault at gunpoint had created well-founded fear in them. I then reviewed Walgreens CCTV. The footage depicted the defendant following the victim's vehicle through the parking lot. Both vehicles drove to the far east side, out of the view of the camera. Shortly thereafter, victim's vehicle was seen reversing westbound through the parking lot while defendant chased him. Victim backed into a curb. Defendant appeared to have stopped his vehicle inches short of colliding with the victim. Victim's vehicle attempted to maneuver around defendant, but crashed into defendant's vehicle, causing the victim's vehicle to be boxed in and immobilized. Defendant exited his vehicle with both arms extended, appearing to have been holding a firearm in his hands. All 5 victims exited their vehicle and laid on the ground. Defendant was transported for a post-Miranda interview. Defendant was read Miranda and then stated the following in summary. While traveling eastbound on Commercial Boulevard, just east of the Turnpike overpass, victim cut the defendant off in traffic, at which point the defendant became angry. Defendant pulled alongside victim's vehicle, exited his vehicle in an aggressive manner, displaying his Florida Department of Corrections badge, stating, "You think this is funny?" demanding the victims pull over. Defendant stated he smelled marijuana emitting from victim's vehicle. Victims drove away. Defendant followed in his car. Victims cut through Walgreens parking lot. Defendant cut them off in his vehicle. Victims reversed. Defendant continued to drive towards them. Victim reversed onto the curb and was unable to evade. Defendant blocked victim's vehicle with the front of his vehicle. The front bumper of both vehicles made contact. Defendant partially exited his vehicle, holding his firearm with his left hand. He pointed to the victim with his right hand. He instructed all parties to exit the vehicle and get down while standing in a law enforcement stance. Victims exited the vehicle, laid face down on the pavement until deputies arrived. Defendant stated he armed himself with his firearm because he did not know if there were any weapons inside the victim's vehicle due to the belief that he smelled marijuana emitting from the victim's vehicle earlier. Defendant stated he did not see any of the victims display any weapons at any time. Defendant was told by the victim that her 2 minor children were inside of the vehicle. Defendant approached victim's vehicle with his weapon still drawn, opened the vehicle door, confirmed there were minor children in the rear seat. He had armed himself with a personal black Sig Sauer .320 40 caliber firearm. The occupants of the other vehicle were the driver, the front seat passenger, a rear seat and 3 rear seat passengers. Defendant was charged with 5 counts of aggravated assault with a firearm, actual possession for each of the 5 victims. There is a lot to unpack.
Let me start with one thing, if I could. The first problem he's going to have is, even if you were to try and argue that he was committing a citizen's arrest, he's not, because the very offense that he says that may have happened is not an arrestable offense. It was a traffic infraction at best. So he wouldn't be able to do a citizen's arrest. His entire behavior was like if these people had just been part of a mass shooting. Just bizarre. I get just as upset when people cut me off and then flip me the bird, or when I pull up next to them and like give them a face like, "Did you not see me?" and then laugh at me. Listen, we've all been there. It's irritating that they think this is funny. But how did he think this was the solution? I'm baffled. I don't understand how he thought this was the solution.
Well, let's start with the fact that this guy is a corrections officer. I take nothing away from corrections officers. It's a very difficult job, mentally, emotionally, extremely difficult. In some ways, much more difficult than actual police, law enforcement officers.
It is much more.
So these guys, look, in their environment, they're on edge. Why this guy was on edge in his personal car at 9:30 in the morning, I don't know. But this is clearly a textbook example of a road rage incident. All right. This guy got so outraged that he was cut off that he chased these guys down at a red light. He got out of his car and told them to pull over. They're like, "Who's this lunatic?" Even if they had cut him off, you have to assume that these people are thinking this guy's crazy and we're going to get the hell out of here, which is exactly what they did. And then he chases them in the car. He gives pursuit until ultimately they're locked in, and now he gets out with the gun and orders them out of the car. Now, I don't know the age of these people. We know that there were at least 2 minor children. They talk about the driver being a male and the passenger being a female. So I'm just going to assume, although I could be wrong, and this is one of the reasons that you really need to interview the individuals and try and, see if you can if we could look at the CCTV footage, which ultimately you got to hope that this officer impounded. But when you look at it, let's just run with the assumption that this is a family of 5. You've got a father, a mother, and 3 kids in the car.
Right.
And this maniac with a gun orders them out of the car and onto the ground as if they had just, were fleeing the scene of a homicide. it just defies any kind of logic or reason. Now, he's charged with aggravated assault with a deadly weapon, in this case, firearm. Okay. Aggravated assault with a firearm is a third-degree felony. It's punishable by up to 5 years in state prison. But if you are actually holding a firearm, if you are in actual possession of a firearm, this would be different with another weapon that is not a firearm, or if somebody else were holding a firearm and you were just present, you were an accessory or a principal or what have you. But if you're the guy with the gun or the girl with the gun, that's a 3-year minimum mandatory on each of those counts. So this guy is now looking at 25 years in prison, coupled with a 15-year minimum mandatory, 3 years for each of those 5 individuals that can all be run consecutive to one another.
Correct.
Plus, he's law enforcement, or should I say, likely soon was law enforcement.
No, I think it's safe to say
the odds this guy is going to keep his job and his certification are probably as close to the odds of Martinez or I winning the Powerball this week.
We got a better shot. We got a better shot of winning the Powerball than he is of keeping his certification. Because like I said, we could talk for hours, okay? But let's say that these people did commit an arrestable offense, okay? His behavior was still so over the top that the offense that these people must have committed for him to behave that way, as Michael very aptly pointed out, would have had to have been like a homicide. If he had stolen something from that Walgreens, this would have been over the top. The only thing I think, looking at this case, if he came to see me, and I think, Mike, you probably agree with me, almost initially we'll be looking at mitigators. We'll be looking at getting him some
mental health case.
Does he have a drug problem? Something where we can say, look, he's not a bad guy. It was a really, really bad moment, a really bad situation and bad moment that he had, but he's not a bad guy, because it's going to be very difficult to be able to figure out any kind of justification for the firearm behavior, for what happened at the Walgreens. Now, getting out of the car, you're screaming, yeah, but the Walgreens thing is just over the top.
Riding on those coattails, I think, as much as you don't want this to happen, in a way, you hope that this guy, was just diagnosed with cancer, or his best friend just died, or he just put down his dog. You want some really horrible event in this guy's life concurrent with this, so that you can at least try and run with some story to explain why he would snap. And you want to hope, I would assume also this guy has no priors, because he probably wouldn't be a law enforcement officer if he did, correct? Right. So you have to assume and hope that you have something there that you can latch onto. This is a case where if it's drugs or alcohol, that may not be all that good, because that's going to affect his licensing as well. But if you can come up with a mental health angle, you might be able to work both ends towards the middle here in terms of trying to help him with regards to the ultimate issue he's going to have with the Department of whatever he works for. If it's Miami-Dade County, the Corrections Department, I'm assuming it's not Broward, but if it's Broward, that falls under BSO, and he's going to wind up having to answer to them administratively. And so one of the things that Ed and I would be able to do with a case like this is to try and set him up with some form of mitigation that will not only help in the criminal case, but also in the administrative proceedings. And then thirdly, on a third tier, individually, because there's something wrong with this guy to have done what he did.
In fairness to him, there really may be something that happened in his life recently. We don't know. I mean, he may be a very nice guy. This was just a one-off. Something has happened recently that he just snapped. It may be true. So it's not like we're going to fabricate anything. Michael's not talking about making things up. What we're saying is we're just hoping that there's something that we could use to be able to explain this as a one-off, as just this is not who he really is. And we can salvage this guy's life. We're not going to be able to salvage his career. I don't think there's anything that we're going to be able to do to salvage his career.
You never know.
But you never know. You're right. We never know.
So I want to also say, relative to what we were talking about with the last case, in this case, the victim called 911. Why did they call 911? Because there was a guy who confronted them in the street, claimed to be a cop, showed him a badge, and tried to chase him down. And these people did not believe he was a cop. They called 911 and they said some lunatic. I don't know what they said, because it doesn't say what they said. But whatever they said probably was along the lines of,
I'm pretty sure I'm pretty sure it's something along the lines of some lunatic.
Yeah. And so, but either way, that call is recorded. And so that's another piece of evidence in this case. It's going to be an excited utterance by her. It's real time. It tracks what's going on in the moment. So it's going to go to the state of mind of those individuals as to what they were thinking. And again, let's say that this guy is actually a cop. That's going to be a defense to fleeing and eluding, right? Because they've made the record with 911. We don't know this guy's a cop. We're not stopping until real cops show up. Please send them right away.
Exactly. And here's the only good, the only thing I can think of that is truly a godsend and a true silver lining of this entire case is thank God that the victims were not armed themselves and there was not a shootout in the middle of that Walgreens parking lot. And it's something we were talking about earlier today, Michael. When you carry a firearm, you know, I've been carrying my firearm, or I've had my concealed weapons license since 1993. And as bizarre as this may sound to some people, I've gone through scenarios in my head over the years constantly. What would I do if this happened? What would I do if that happened? And in this case, thank God this man in the car didn't have a firearm. And if he did, hopefully he wouldn't have just pulled it and started firing. Because can you imagine if this corrections officer, if the victim had fired on the corrections officer in self-defense and the corrections officer said, well, now I got to fire in self-defense. Forget about hitting the guy who was shooting or the woman. What about a straight bullet who killed these kids?
Yep.
You know, when you got a firearm and you can carry, you've got to be concerned with, first and foremost, the safety of everyone. And I know this is going to sound corny, but if you ever look at these superhero movies, what is Captain America always concerned about? Safety of the civilians first. You've got to do that when you're carrying as well. It's a huge responsibility to carry a firearm for self-defense. And one of those is you've got to make sure that everyone around you is safe first. That's always the prime objective. And thank God that this man didn't pull a gun on this corrections officer, because it could have been really bad.
I want to give a shout out to the officer who wrote this A form for two things, and then one question mark that I have. I want to say it's good police work to document the scene with intent. So when he says, quote, I reviewed Walgreens CCTV, let me tell you, more than 1 out of 2 officers are not going to go look at that CCTV.
Correct.
They're never going to bother to take the time to do it. The fact that this guy did is important because he's listening to both sides of this story, and now he's got some independent corroborating information that he can determine who's telling me the truth, who's embellishing, what is being left out. He can make a much more informed assessment. The criticism that I have is there's no indication in this arrest report that he impounded or copied or requested that CC footage be preserved. That ought to be notated in here. If I were the officer, or if I were the officer's supervisor reviewing this, I would have said, where's the CCTV? Put it in the A form so that the assistant state attorney and the defense attorney and everybody else on the planet who reads this knows we did our job and we preserved the evidence.
Absolutely. But also, like you said, we don't know if he did that. And in fairness,
probably did, but
and in fairness, remember, guys, there's also the offense incident report. This is the arrest affidavit. All these cases all have is an offense incident report as well. And the good detectives, the good cops, will put things like what Michael's talking about in the OI, because it's not necessary for probable cause. But Michael's right. It's really a good idea to do it and make sure everybody knows. So maybe he did. Maybe he did.
I want to point out one other thing in here as to good probable cause affidavit form. When he talks about his interviews of the victims, he puts this language both times intentionally. Quote, the defendant created a well-founded fear in the victim while pointing his firearm at him. Why is that language in there? That language is in there because those are the statutory elements of the crime of aggravated assault. The individual must actually be in fear. It's not enough that I do it, because if I point the gun at Martinez, but Martinez knows it's a cap gun, there's no fear.
Right.
If I point the gun at Martinez and he says, I was afraid that I was going to die, it doesn't matter if it was a cap gun because he had the fear, right? So the fear is really the essential element. And the fact that the officer went to pain to put that in there, not only for the initial interview of the driver, but then again, the officer puts it in there and says,
right.
when he interviewed the other individuals, they affirmed the assault at gunpoint created a well-founded fear and they want to pursue criminal charges. So part of this calculus, and remember, this document is a statement of probable cause. That's what we said it is. So probable cause means they've got to hit all the elements of the crime. They fail to hit the elements of the crime. We have an argument to make in front of the bond judge. There's no probable cause here for the arrest. It doesn't mean the case won't get charged. It doesn't mean the state attorney might not file charges. They might. But you're not going to have to go out of pocket for bond if we can prove there was no probable cause for the arrest. At least we could do that, which is actually important on two fronts. One, financially, right? You don't have to worry about being on the hook for money. But more important, because even if you have pretrial release and it's not, a cash bond, either way, you're not subject to bond revocation if something happens while this case is pending, if there's no bond.
Right.
So you could still be prosecuted. You could still face, a conviction or jail time at the end of the day, but you cannot be violated for a violation of pretrial release conditions if there was no probable cause in the arrest report. And that's part of the judge's calculus.
And that's a good point you make, Mike, because we see so many officers that don't do that. And to my prosecutor brethren and to my learned friends and colleagues sitting on the bench, many times you'll see a case like this where the officer may not write the person had a well-founded fear. And we'll come in and say, Judge, there's no probable cause. Nowhere in the four corners of the A form, which is all the judge can look at, does it say that anybody was in fear. And we'll have judges say, Mr. Martinez, they pointed a gun at him. Do you really think he wasn't in fear? That's not the point, Judge.
Not what we think. It's what the document says.
Right. And to my prosecutor colleagues as well, your job is to make sure the officers do the job better by constantly bailing them out. It's like when you bail your kids out of their problems. They're never going to be able to solve their own problems and get better at what they do. So a judge could say, sorry, I don't find probable cause for, we're not going to dismiss it, but I don't find probable cause for a bond. What does that mean? Now prosecutors have to clean up the mess. And the prosecutors can. They'll bring the victim in and say, hey, did you fear? You swear to tell the truth, the whole truth? Yes, okay. We give them the interview. It's called the pre-file. Did you fear for your life? I feared for my life. Got it. But then you got to turn to your cops and say, guys, you see why you had to put that in there? This guy now is out with no, ROR because you didn't put it in there. It makes it a better law enforcement.
I'll give you a really relatable analogy. So if you get a ticket for careless driving citation requires the officer to put in the citation what it was that constituted careless driving. It's not enough to say he was driving carelessly. They have to say what you did, right? So if they fail to express in the charging document, which is a traffic ticket, careless driving, they check the box, they put the statute number, and then underneath they say defendant was driving at an excessive speed in poor conditions during the rain, weaving in and out of traffic. That ticket is valid. But if they don't put any of that, and they just check the careless driving box, it's going to be dismissed. Now, again, it's not a crime. It's a traffic infraction, but the principle is the same. The principle is you're being accused of something by the government, and the government you have due process rights. And part of your due process rights are to be put on notice of what the charge is. Careless driving is the name of the charge, but it doesn't tell you what you did. So, for example, if you get charged with speeding, you know you were speeding. You may not know what speed you were going. That's another story. But speeding is speeding is speeding. There's no confusing it, right? Driving in the wrong way on traffic. There's no confusing it. The charge is what it is. But careless driving requires some combination of offenses. And that's why there's an additional burden that they say what it is that constituted careless driving. Same with the criminal variety of that charge, which is a step up called reckless driving, right? They have to say, what did you do that was wanton and willful disregard for persons and property? What was the behavior that made it reckless? And if they don't spell that out, you're going to get that case dismissed.
And he did another thing that was very nice about this. A lot of times officers will be like, well, I don't have room. I don't want to write so much. If you notice, he actually accomplished putting in the probable cause of the well-founded fear in half of a sentence that was a necessary sentence. In other words, what I'm saying is, he said that the defendant got out and pointed a gun at these individuals. That's going to have to be in the A form. We know he was going to have to write that, but all he did was add the other part, establishing a well-founded fear. That's it. That's all he had to do. When I used to teach at the academy, this is one of the things I used to try to tell these guys: be concise, but you can be complete. So you don't have to add a complete new sentence or a whole other paragraph. It's just 3 other words, 4 more words, and you're done, and you establish something you need.
The longer that they're on the job, the better they get at it, as a general rule. But officers have a cheat sheet. They have, at least here in Dade County, this is an older one, but every year it comes out. This is the Law Enforcement Handbook. It's an absolute cheat sheet. They get to sift through this thing, and it tells them exactly what they need to put in their police reports, and it tells them exactly what charges they need to levy in any circumstance. But even a rookie can always call in, and should call in, a more senior and experienced officer. And a lot of times, I mean, Ed will tell you, I know he gets them just as I do. We get calls from our law enforcement friends. Mm-hmm. I got one today. A law enforcement officer wanted to know if it was okay for him to fly a drone over somebody's property so that he could verify whether or not there was a grow house going on. So, the point is, right, wrong, or indifferent, props for him to picking up the phone and calling a seasoned defense attorney and saying, listen, I'm thinking about doing this. He didn't call a prosecutor. He called a defense lawyer.
That happens more than you think, man.
So there's a lot of good cops out there doing their job, but these probable cause affidavits, they're can be the death of you, but they can also be the death of the state's case too. Right. So, you just have to be clear, and you need a lawyer who goes through them with a fine-tooth comb, understands the nuances, is able to detect loopholes and technicalities, is able to find factual or legal or procedural or substantive errors or mechanisms that we can use to levy challenges, be them for suppression or dismissal or any other purpose. And most importantly, we have to follow up, because again, let's take our corrections officer. We don't know what's going on in this guy's life. Nothing's going to justify what he did, but we may be able to mitigate against it. And we may be able to do that in a way where we're trying to convince these people, hey, give this guy a break. And by the way, I know we're running over, and I'm sorry to keep going on this, but the one thing we didn't talk about is his excuse as to why he did this is so lame and absurd as to be laughable. Okay. He doesn't blame it on being cut off. He blames it on, they may have been armed because he smelled marijuana.
Oh, that's ridiculous.
I mean, it doesn't get more absurd than that. And so I think, part of that goes to, don't say anything. This guy would have been better off shutting his trap and saying nothing and letting his defense attorney try and come up with some rational explanation if there is to be one. And if there is no rational explanation, better no explanation than a bad explanation, because those words are going to haunt this guy until this case is over.
If there's any overarching theme, I think that we can do here, kind of like the South Park moral of the episode is, call the cops as often as you can. Always, your first instinct should always be 911. Whether you think it's some guy that's acting like a cop, but you're not sure, and he might be a little unhinged, or you think somebody committed a crime, call 911. Then, in the last resort, if you got to take care of things yourself, fine. I'm all for self-defense and defending ourselves. But for God's sakes, always try to have the cops do it first.
You had to bring up South Park, because now all I can think about is, Ed, you're big boned.
It's genetic, brother. It's genetic. That's all muscle, buddy. All muscle.
Thank you, everybody, for indulging us for episode 52. Next week, we have a guest scheduled. We have what I think is going to be an excellent show on electronic evidence. You guys are going to learn how your cell phones, your smartphones, your tablets, your Ring doorbell videos, your apps, your smart locks at your hotel rooms, all your Alexas, your Google Assistants, how all of these things can conspire to screw you in a courtroom,
or
exonerate you, So either way, we've got an expert coming on who is a lawyer who doesn't practice law anymore. Now he's a what they call an electronic evidence expert, and so he testifies in various proceedings about electronic evidence, mining it, using it. Really, really cool stuff. So we're looking forward to having that discussion next week. In the interim, I apologize for running over again. Martinez, no, you're this way. Boy, I can't get I don't know whether I'm coming or going today.
Just point in the opposite direction that you want to point. Whatever your instinct is, go the other way.
It's like turning the wheel on my boat. Anyhow, y'all be good. Thank you, Ed, and wishing everybody a really good week. And we'll look forward to seeing you next week and being at your service with episode number 53 on Monday, the 24th. Thank you again, and take care.